What's going on, everybody? News Now Wyoming here, bringing you another episode. This time, we are coming back into the Jack Miller versus Stupid Cop story. As a reminder, because it has been a while, this is a story about a man who was arrested in Walmart for failure to show his ID. No other crimes. They didn't even have him suspected of a different crime. Just based off of some random caller's thing, they showed up and then demanded his ID. They didn't even have confirmation that he was the person that they were looking for. So this lawsuit was a result. In the last video, we talked about a requirement by the judge to file a response to the request to dismiss the charges. Since that time, we've got this response here, and she's made them turn in a scheduling for motions and stuff like that. Everything is due at the end of June, so we should start seeing more activity in July. Again, it'll be a slow process in July, but let's go ahead and get back to this response. As a reminder, once again, the attorneys for the stupid cops put in there that they should get qualified immunity because they just deserve it. They're cops. Yes, we know we broke the rules. They even admit that they broke the rules and that it was clearly established, but they should still get qualified immunity. So, let's go ahead and go into this. There was one count that I think might be dismissed because it's a Texas count, and Texas makes cops immune if they were in the duty. So, holding a cop accountable for something, it may not happen, but we'll go ahead and wait and see. Okay, so Table of Authorities, Rule 7A reply, blah, blah, blah. We're going to continue skipping down, do the fun stuff. And yeah, look at all of these citations. Oh my gosh, I am loving it. Jack, your attorney has done something that so many attorneys do not. How easy is this to actually follow? Anderson versus Crichton, Ashcroft. Oh, that is a big one. Ashcroft versus Iqbal. Oh my God. All right. So those are going to be your Texas. This one here for sure is your Texas ID 3802. Guess we'll find out what Bell Atlantic is for. Yeah, Darden and City of Fort Worth. To make why the city's not immune, but they didn't actually sue the city. What else was decided in Darden? I guess we'll find out. Alright, but this is awesome to actually put this at the front. Thank your attorney, Jack. Wonderful job. Obviously, Terry v. Ohio, which made it legal for them to stop you and ID you if they suspect you of committing a crime. And that was only if the state law allows that, which Texas does not allow that. And then the code's Texas Penal Code 3802. Alright, let's get into this. This is already just way too much fun. I've missed this. Alright, so it comes now. Jack Miller files 7A reply. Okay. Cases involving claims of qualified immunity often is appropriate to require plaintiff to file a detailed reply to address the plea of qualified immunity. However, a reply is only required when the claims and complaint are not supported with sufficient precision and factual specificity. Big word. Sorry, guys. I'm just too excited. To raise a genuine issue as to the illegality of a defendant's conduct at the time of the alleged acts. In this case, plaintiff's original complaint included a detailed factual recitation of the event which forms the basis of this lawsuit, which raised a genuine issue as to the illegality of the defendant's conduct at the time of the alleged acts. Incorporated a video of the incident that forms the basis of the lawsuit, clearly depicting the events as described in the original complaint. And included citations to reported decisions of the Fifth Circuit, included Davidson versus City of Stafford, which we have looked at in a previous case, supporting plaintiff's contentions that the law was clearly established at the time of the incident that forms the basis of this lawsuit, particularly given the facts of the case. Plaintiff believes that his original complaint sufficiently addressed the issues relevant to the defendant's claimed defenses of qualified immunity. However, pursuant to this court's order, he'll address these issues below. So, hey, stupid judge, you're making us do this, but we don't think we should have to do this. You're making us waste our time, is what this attorney is doing. Maybe not rubbing it in the judge's face that the judge screwed up with the order. Yeah, I didn't think it was required either. I thought it was a stupid requirement. But, who knows? I'm not a judge. Alright, so standard of review for pleading sufficiency. At this stage of the proceeding, plaintiff need not come forward with evidence to support his claim. He is merely required to plead all allegations that, if true, would defeat the qualified immunity defense. And so what that means is to overcome this motion to dismiss, the judge has to consider everything that Jack Miller says as true. There is no, is this true or not? That does not matter. Everything Jack Miller says is the truth. He is the non-moving party. So everything he says at this point is taken at face value. To overcome an official's qualified immunity defense, a plaintiff's complaint must allege specific facts that, if later proved, would show that the official's conduct violated clearly established constitutional or statutory rights. The pleading standard in qualified immunity cases requiring allegations of fact focusing specifically on the conduct of the individual who caused the plaintiff's injury. This court must continue to apply all the traditional rules that favor plaintiffs on motions to dismiss. It cannot look beyond the pleadings, must accept the allegations in the complaint as true, and must view them in the light most favorable to the plaintiff. Plaintiffs are merely required to state a claim to relief that is plausible on its face. The Supreme Court has held that the plausibility requirement does not require the plaintiff show a greater probability of success than the defendant at the pleading stage. It simply requires the plaintiff to raise a reasonable expectation that discovery will reveal evidence to support the allegation. And that's in Twombly, which we have also covered. As we understand it, the court is saying in Iqbal and Twombly that the plaintiff must give enough details about the subject matter of the case to present a story that holds together. In other words, the court will ask itself, could these things have happened, not did they happen? So although they provided video evidence, it is not required at this stage. Finally, the Fifth Circuit has held that an allegation is plausible if reasonable minds can differ as to its veracity. Put otherwise, a factual allegation is only inadequate if no reasonable person could believe it. Wow, what does that mean? That actually means, and let's get that mic turned up a little bit more because I'm a little silent. So I apologize, it just got a little louder in your ears. Okay, government, but factual allegation is only inadequate if no reasonable person could believe it. So, if I were to write in a complaint that Jack Miller hit me so hard I flew over the moon and now I am suing him, that would not survive a motion to dismiss because nobody would really believe that happened, right? Okay. That's an extreme example. Government officials who perform discretionary functions are entitled to the defense of qualified immunity, which shields them from suit and liability for civil damages if their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. The Supreme Court initially set forth a mandatory two-part inquiry for determining whether a government official was entitled to qualified immunity. And we've covered this so much, I'm actually going to skip this. We have covered this part so much. So, we're going to go ahead and skip that section of the lawsuit. Again, you guys are able to go pay for this document, download it, and read it at your own leisure. We're not going to cover this again and again and again. We've got videos upon videos to cover it. So, argument and authorities. The defendant in this case are not entitled to qualified immunity for the conduct alleged in the original complaint. As will be discussed, the clearly established law of the Fifth Circuit put the defendants on notice that their conduct violated Miller's constitutional rights, which I've pointed out with the case law in previous videos. Under Texas law, the defenses of qualified immunity and official immunity, though similar, are distinct. Qualified immunity generally applies to claims under 1983. Official immunity applies to state law tort claims. As this court's order instructed plaintiff to file a Rule 7A reply regarding the issue of qualified immunity, only the federal 1983 claims will be addressed below. I think they are making an error here in not addressing the state claim. Because with the state claim, they are using a state law and a state, they're not using a federal law to say here's why they should be sued for endangering my child or causing emotional distress to my child or whatever the statute actually says. And that is not something that can be brought to federal. So by not addressing the state tort claim here, I do believe that is an error. But again, let's go through here. Unlawful arrest, violation of the Fourth Amendment. So the stupid defendants deprived plaintiff of his constitutionally protected right to be free from unreasonable seizures under the Fourth Amendment by unlawfully arresting him despite lacking probable cause that any crime had been committed, as he was not under arrest at the time he was asked and then refused to identify himself, and he had committed no crime. Stupid defendants violated his right to be free from unreasonable seizure under the Fourth Amendment. A false arrest requires showing of willful detention, yes. Without consent, yes. Without authority of law, yes. And the deprivation of a constitutional right, yes. Stupid defendants intentionally arrested him by restraining him in handcuffs and later confining him in the back of a police car without a warrant, without his consent, and without any legal justification. Mr. Miller did not consent to his restraint or confinement and was conscious of both. Stupid defendants willfully arrested plaintiff by telling plaintiff he was being arrested and by restraining plaintiff in handcuffs and later in a patrol vehicle. He did not consent to being restrained in handcuffs or being restrained in the patrol vehicle. Again, very clear in the video. They put him under arrest. They do not, in their reply, try to say that they did not arrest him. That's something that they've done many times in lawsuit replies of, yes, we told him he was under arrest, and yes, we put him in handcuffs, but we didn't really arrest him. They didn't try to do that here because they know that's a stupid argument. He was under arrest. There is no cause of action for false arrest under 1983 unless the arresting officer lacked probable cause. To determine the presence or absence of probable cause, the totality of the circumstances surrounding the arrest must be considered. Stupid defendants did not have probable cause to support arresting Mr. Miller, as they did not see Mr. Miller commit a crime, and he was not under arrest at the time he refused to identify himself. Thus, the failure to identify offense under 3802 was not triggered, since it applies only when an officer has lawfully arrested the person and requested the information. Additionally, stupid defendants admitted to Sergeant Brian Holt they did not have probable cause to arrest Mr. Miller for any other crime, and that's in the stupid camera, right? Stupid defendants did not have authority of law to arrest Mr. Miller, as they did not have a warrant or probable cause to arrest him, and no other exigent circumstances existed justifying his arrest. By knowingly and intentionally arresting Mr. Miller without consent, without probable cause, and without legal justification, stupid defendants deprived Mr. Miller of his Fourth Amendment right to be free from unreasonable seizures. Yes! As a result of the illegal arrest, Mr. Miller suffered injuries. As a result of the illegal arrest, stupid defendants deprived Mr. Miller of his civil, constitutional, and statutory rights and are liable to Mr. Miller pursuant to 1983. Mr. Miller was damaged as a result of defendants Weber, Mayberry, and Francis's wrong acts, as his liberty was deprived, and he suffered the emotional distress and mental anguish of seeing his son cry out in fear. That wouldn't be a Fourth Amendment. Additionally, when making the illegal arrest, they injured him, causing him physical pain and suffering. Constitutional right under the Fourth Amendment not to be arrested absent probable cause under these exact circumstances was clearly established at the time of the illegal arrest in this case. Keep calling it illegal. Yes. Maybe there are charges. I wish prosecutors would start prosecuting cops for illegally kidnapping somebody. Oh, how awesome would that be? Not in this lifetime. No right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint and interference of others, unless by clear and unquestionable authority of law. Terry v. Ohio. There could be no doubt that the right not to be arrested absent probable cause was clearly established at the time of Mr. Miller's arrest. The Fifth Circuit has addressed the exact facts of this case and denied qualified immunity when finding that police officers lack actual or arguable probable cause to arrest a person for failure to identify, in violation of Texas law when the person has not yet been arrested at the time that he fails to provide officers with identification, because the failure to identify offense is triggered only when a person who has already been arrested fails to provide ID. And Davidson predated Miller's case by 3 years. And there was actually an earlier case that I pulled up that was also Fifth Circuit. Can't think of what it was. That decided the exact same thing 10 years before Mr. Miller's case. So it was clearly established. The facts in Davidson are identical to the facts in this case. Flagg also asked Davidson for identification, said he did not have any identification and that his name was Jonathan. Officer Flagg repeatedly asked him for identification or his last name, to which Davidson responded with either Jonathan or John. Based on these responses, Flagg and Jones arrested... No, excuse me, something in my eye. Jones arrested Davidson. As they arrested Davidson, this officer stated, "You don't have ID, you go to jail. And when you fail to go ID, you go to jail." Upon a request from Davidson to know why he was being arrested, one of the officers stated, "Fail to ID when we're conducting an investigation. Did not identify yourself to the police." He again informed the police officers of his name was Jonathan and that he was not operating a motor vehicle, but an officer stated, "When we're conducting an investigation, fail to give your name to the police, you go to jail." The Fifth Circuit found that the defendant officers in Davidson were not entitled to qualified immunity because they were objectively unreasonable in believing that there was probable cause to arrest the plaintiff. They explained, "We agreed with the district court that there was no actual probable cause for his arrest. At the time the stupid cops arrested Davidson, the only crime charged to Davidson was a failure to identify under 3802. This is further confirmed in Davidson's police report, which charged Davidson with failure to ID under 3802A, but 32A applies only when an officer has lawfully arrested the person and requested the information. At the time they performed the arrest for the alleged 3802 violation, Davidson was not under arrest for any other violation. Thus, the failure to ID statute clearly was not triggered. We therefore conclude that the district court correctly determined that officers had no actual or arguable probable cause for arresting Davidson under 3802. Fifth Circuit then stated, in addition to cases establishing the lack of probable cause, there was fulsome case law clearly establishing that an arrest without probable cause violates both First and Fourth Amendment rights at the time of his arrest. In the present case, Miller was arrested for failing to ID himself. Okay, so maybe it was Davidson we looked at, because that says his arrest was in 2013. So maybe it was Davidson we looked at. Or did we look at its precedents? I don't remember. Alright, in the present case, Mr. Miller was arrested for failing to ID himself despite not being under arrest at the time. These facts are identical to the facts in Davidson, where the Fifth Circuit held that the defendants did not receive qualified immunity for the illegal arrest. Neither should the defendants in this case. As the law was clearly established at the time of his illegal arrest, stupid defendants are not entitled to qualified immunity. Excessive force. Acting under the color of law, stupid defendants deprived him of his rights secured to him by the Fourth Amendment to be free from unlawful and unreasonable seizures by the use of force. An unreasonable seizure, if it results in an injury, and it did, that resulted directly or only from a use of force that was clearly excessive. Okay, so pushing his neck up against and all that stuff. And the excessiveness was clearly unreasonable. And I would argue, once again, the courts have disagreed with me. So I get that the courts do not agree with me. But any force, when the arrest itself is unreasonable, any force should be considered unreasonable. Period. There should be no ifs, ands, or buts. There should be no confusion there. If it is an illegal arrest, any force should be considered unreasonable. These injuries were not caused by any other means. The amount of force used by each defendant of the stupid defendants slammed the already handcuffed Mr. Miller against the drink cooler. Each of the stupid defendants pressed his head and neck against the top edge of the cooler. And then each of the stupid defendants raised his arms up behind his back and held him in that position until his rotator cuff was injured, was objectively unreasonable under the circumstances and inflict unnecessary injury, pain, and suffering upon him. He was not suspected of committing a felony offense when each of the stupid defendants slammed him against the drink cooler, when each of the stupid defendants pressed his head and neck against the top edge of the cooler, or when each of the defendants injured his rotator cuff by raising his arms up behind his back and holding him in that position. He was only suspected of committing a minor offense for failure to ID, which he had not even committed. Yes! That's what I always say. Courts disagree with me on that. He was not attempting to flee, as his 3-year-old son was with him. He was in handcuffs, being held by 3 officers. He was calm and compliant the entire time. No, when he put... okay. I could argue either way. Watching the video again, I could argue that he wasn't completely compliant. But again, he wasn't forcefully fighting them. So, he was not threatening any officer or other person immediately prior to when each of the stupid defendants slammed against the drink cooler, or when each of them pressed his head and neck against the top edge of the cooler, or when they injured his rotator cuff by raising his arms up behind his back and holding him in that position. He was not arrest prior to when each of the stupid defendants slammed against the... Okay. We're not reading that over again. Although they may need to use physical force to effectuate a suspect's compliance when he refuses to comply with commands during a traffic stop, they still must assess the relationship between the need and the amount of force used. Where an individual's conduct amounts to mere passive resistance, use of force is not justified. And that's huge. So even though I say that he was not completely calm and compliant, the amount of force they used was in excess. A constitutional violation occurs when an officer tases, strikes, or violently slams an arrestee who is not actively resisting arrest. And I would argue he was not actively resisting arrest. He was not actively resisting a lawful or an unlawful arrest. Okay. Fifth Circuit case law makes clear that when an arrestee is not actively resisting arrest, the degree of force can employ is reduced. Mere passive resistance, use of force is not justified at all. They have found that the law is clearly established that it is objectively unreasonable for several officers to tackle an individual who is not fleeing, not violent, not aggressive, and only resisted by pulling his arm away from his grasp. So that's clearly established. I agree. All right. Yeah, we're going to go ahead and skip the rest of that one. Yeah, I love it. Keep bolding that out there, which he had clearly not committed. Due to the clearly established law, a reasonable officer would know that the use of force is clearly unreasonable when engaging with citizens such as Mr. Miller, who was not threatening any officer or other person, who was only suspected of committing the misdemeanor crime of failing to identify himself, which he had not clearly not committed, was not attempting to flee, and was not resisting arrest. Yeah, all right. Plaintiffs respectively submits stupid defendants should not be granted qualified immunity. Again, I think they are in error by not addressing the state tort case part of it. Because, yes, they are following the letter of the order. They are following the letter of the order here. But the judge can still rule against them on that state because they did not reply to it. So, I am concerned about that. If that is actually a true concern, I don't think it's going to survive being killed anyway. So there we go, you guys. Welcome back to the channel. Welcome back to Mr. Miller and the stupid defendants. This is a great case. It's going to be a fun one to track throughout this process. There will be there are conferences. Let's look at the. Oh, I can't look at the docket because it opened up in this window, but there will be different things coming here at the beginning of July, and so we will try and follow this case closer. Welcome back. I'm excited to get back into it. So thank you guys for joining. Have a great night.